the negotiations held throughout this week at the Assembly of State Parties on the amendment to the rules of evidence and procedure of the court. It is important to point out from the outset that the court has two primary documents. One is the Rome Statute itself, which is the statute setting out the structure, jurisdiction, and other related matters relating to the officers of the court and the procedures of the court. But it is the rules of procedure and evidence that govern how the court deals with cases on a day-to-day basis. We came to this meeting with two outcomes in mind. The AU and African state parties have expressed the wish that Rule 27 of the Rome Statute itself, which deals with immunities, should be reviewed. That request has already been placed before the relevant body of this assembly. It cannot be debated now. We did not expect it to be debated now. We are familiar with the statute. I have read reports indicating that we arrived here and we are surprised to learn that the statute says something. We've been aware of what the statute says since Kenya became one of the first countries in the world to sign the Rome Statute. We became the first country, one of the first countries in the world to ratify the Rome Statute, and certainly one of the first countries in the world to domesticate the Rome Statute and to make it what in Kenya we call the International Crimes Act, which may explain why when Kenya is served with a summons for the arrest of somebody, we do not come back to the Rome Statute, we go into the International Crimes Act of Kenya, and that's where we find the procedure. We have, however, in the last 3 days, addressed specific rules of procedure and evidence, and in particular, a new Rule 134 that deals with excusal from presence at trial due to extraordinary public duties. And I'm happy to confirm to you that as at this review, the amendment has been carried from the drafting committee to the working group by consensus without demand. And it is therefore our expectation that as at Thursday, the new one, Rule 34 term, will become part and parcel of the rules of procedure and evidence of the statute of the court. What is the import of this rule? The import of this rule that a person who is under any constitutional or legal order is carrying out extraordinary public duties at the highest state level, which includes the president, the deputy president, a prime minister, or such other person. If he submits a request to the trial chamber, he will be excused from attendance at court as long as he is represented by counsel and he has waived his right to attend the trial, and the court has satisfied itself that his rights will be protected appropriately. In our view, this amendment has secured a fine distinction between the immunity of a head of state, which will be dealt with by the treaty at an appropriate time, as I have stated, and attendance before court, which is procedural question. We thought that you would want to have that clarification made so that you may be able to make any clarifications in respect of prior reporting in respect of this matter. We have been supported, Kenya and the AU and the African states have worked together and we wish to pay tribute in particular, but without any distinction, to the very able representation accorded to the Republic of Namibia, and they're here represented by the Attorney General, and the Republic of South Africa, the Republic of Uganda, and several other African delegations that were part of the contact group that was working on this effort. I want to conclude by saying Kenya believes, the AU believes, and Africa believes that these are not rules that have been inserted into the statute for the here and now. They are rules to improve the performance of the court, and that is why they have the support of all members of the Assembly. We have arrived at the ratification of this rule without a single dissenting voice, because everybody believes that the court must be assisted to improve its procedures. Thank you very much. I'll take one or two questions. Yes, sir.
I just wanted to find out what is the implication of this rule and the decision that was in the appeals chamber? What does that mean? And what's the outcome?
The rule that the court interpreted before, when it dealt with the case of the deputy president and indeed the case of the president, was the previous rule. And therefore, what has happened today, or rather what we expect will happen on Thursday, that there will be a fresh rule creating special and extraordinary circumstances that have not existed before. And therefore, we would expect, obviously, upon the counsel that the respective parties may receive, that a different application may be preferred to the court as appropriate. But you know that for our purpose here, we are here to deal with the rules and the rules only. As you know, both the president and the deputy president are ably represented by very, very competent counsel. So none of us around this table can pretend to know what they will do or not do. What we can tell you is that we have come here, and with the support of the whole Assembly, we have achieved the amendment of the rule for the better working of the court.
I'm sorry, just a follow-up on that one. Does that mean then therefore that the lawyers of Ruto or Uhuru will have to make a fresh application, in which case then the court will apply this new rule?
We don't know what any team will do on either side or what the prosecutor will do. What if you are asking, does this new rule entitle either of the parties to make a fresh application on the basis of this new exceptional, extraordinary circumstances? The answer would be yes. There is no other question. Thank you very much for coming and for the support you have given us media to informing our countrymen as to what is going on here. Thank you very much.
go ahead.